A longtime city worker recently won a discrimination case against her employer with a jury awarding her almost $11 million. The city was accused of racial bias, and the employee had also brought a complaint to the Massachusetts Commission Against Discrimination. To tell us about how the complaint process works and how the agency can help is our guest, one of the commissioners who works on a majority of the investigative cases, Sunila Thomas-George. Thank you very much for being with us.
Thank you, Chris. I'm very happy to be here today.
I want to start with a little of your own history. Is that you go back a ways too, and you were put on by one governor and reappointed by another.
I was initially appointed in 2007 by Governor Deval Patrick, reappointed a few times after that, and I was just recently reappointed by Governor Charlie Baker, and I'm thrilled to have the appointment. I'm really very happy that he saw fit to allow me to continue my service with the commission, and I think it really goes to the governor stating that he wants subject matter expertise in government, and that my appointment is really evidence of that, of the subject matter. And I really hope that he is thinking of me when he thinks about subject matter experts in people to improve state government and making it more diverse.
Well, the story I alluded to in the Boston Globe is about racial discrimination, but talk about the categories, because this is not just about race.
That's right. We actually have a lot of protected categories at the MCAD. We protect individuals in Massachusetts or those visiting Massachusetts in race, color, national origin, handicap discrimination, a lot of people say disability discrimination, age, over 40 in most cases, religion, sexual orientation, transgender, sexual harassment, religion. So we have lots of protected classes, and we have even more of those when we protect in housing as well.
How do you investigate these cases?
The investigation starts with an intake. People come to any one of our 4 offices. We have offices in Boston, New Bedford, in Worcester, and in Springfield. I serve as one of 3 commissioners, as you alluded to. I have 2 co-commissioners. One sits in the Springfield office. She is our chair of the MCAD, Jamie Williamson, and I think you know our 3rd commissioner, yes, Charlotte Golar-Ritchie, who I am honored to sit with in the Boston office with.
I imagine in a lot of cases you have somebody who brings a complaint, they feel that they've been treated badly in some way, and it involves, well, knowing what the people around them would say. So sometimes that must be tough to cut through and know who's telling the truth all the time.
Yeah, so even going back to your last question about how do we investigate, it starts with the intake. You come in, we'll help you file your complaint. So you tell your story, you tell us what happened. Was it in employment? Was it in a housing landlord situation? Was it at a place of public accommodations? We then draft the complaint, help you draft the complaint. We then serve that complaint on the other side. The investigation goes into what is the response from the employer or the business or the landlord. They're allowed time to file a response. The complainant, the charging party, the person who brings the complaint, is also allowed to file a rebuttal on the case. And we look at those pleadings. We have an investigative conference. There's a lot of discussion between the investigator and the complainant, the charging party, as to the information needed to see whether or not probable cause exists. And that's what we're looking at. We're looking to see if there's probable cause.
Well, you could end up with conflicting accounts and gray areas, and I guess you have to mediate sometimes, right?
The alternative dispute resolution that we have at the MCAD is a big component and a big resource for what we do at the MCAD. One of our what we like to do is we like to try to resolve cases, and we try to resolve those cases through mediation, through conciliation, and it is an opportunity that the parties get throughout the whole process. So it's not a one-time deal. Really, we allow the parties to come in basically at any time they feel ready to come together to allow us to help facilitate resolving the issues in the case.
Yeah, when we talk about at least allegations of workplace discrimination, one thing I can imagine happens in a lot of workplaces, whether they're in government or private sector, nonprofit sector, is that when a new person is in charge, they want their people, doesn't mean necessarily of a given race, but they want people that they feel more comfortable with.
Yep.
And sometimes that means that some really good, qualified, dedicated people going to get pushed out.
Yeah, unfortunately, we don't have a protected class for hiring people that are people or people that you prefer. There's no protected class like that. It is illegal to bring on people that you know. And but yeah, I understand that it's hard for people who don't have an affiliation or don't have a relationship with that new person who's coming in. But I think I think the basis for your question is that employment is at will, pretty much anywhere. And so unless it's based on a protected class, it's not considered discrimination. So if it's not based because of your age, you're over 40 and the person has wanted you out because they want to bring in new people. It's based on your religion. People don't want to bring people on or promote people of a certain religion. They don't want to accommodate your disability, or they just don't like you because of your race and color. Those are areas that we protect in our mission.
I want to bring you close to a borderline here. Say I'm a boss, I come in, there's somebody who is okay, I would rather replace them, but either because of their age or their race or sexual orientation, I'm worried. Does that mean if I put some incentives for them to leave that I'm discriminating against them, or what?
Well, I think it depends on the facts. We definitely see a lot of cases of discrimination. We have a probable cause rate close to 20%. So we do see cases where race or age could be a factor in the decision making. However, it all depends on the facts of a case as to whether or not employers, what they're doing is, legal, whether it's within the boundaries of the law.
What about the decision about whether to stick with your process or to just take it to court?
Well, that's a very good question, and about, I'm sure that every case that comes in, mostly those with attorneys, they have that process and they go through that process with their attorney. There are benefits to staying at the MCAD, and there are benefits to going to court as well. The benefits to staying at the MCAD is, you'll have a subject matter expert hear your case. So it's not just, a jury of your peers, but it's a subject matter expert. Some of the challenges to being at the MCAD is the time it takes. I think that a lot of people know that it does take time. We don't have quite the resources we should have to investigate all the cases that we have. We probably have about a third of the resources we need in order to address the more than 3,000 cases that come to the MCAD every year. But even with that high number of cases, only 10% of the cases actually are removed to go to court from the MCAD. As you saw, there was a big jury award in this particular case. Although, our commission does have awards of damages, we don't give punitive damages. And that's a big distinction between us and the courts. The MCAD has damages for back pay, for emotional distress. We definitely give awards of damages for attorney's fees, but we don't have punitive damages. But we have something very different. We have civil penalties. Civil penalties don't go towards the private remedy, and so it doesn't go to the person bringing the case. It actually goes to the Commonwealth's general fund. But sort of the same analysis is used, where the courts look at, whether or not the person who's discriminating, the conduct was outrageous, the conduct deserves to have punitive damages. We would look at the same thing at the MCAD too, whether or not it warranted a civil penalty. The difference is the civil penalty goes to the Commonwealth, where the private, where the punitive damage goes to the private citizen.
What about the mix of your cases? I know we've been talking about workplace discrimination, but
Yep.
What kinds of other cases do you usually see?
Well, about 10% of our cases are housing, and about 4% of our cases are places of public accommodation. And let me explain that. So places of public accommodation are businesses such as a movie theater, restaurants, museums, places where you would go for the general public, libraries, that you could go, and if you felt you were being discriminated against based on a protected class, you could come file your case with the MCAD. And Chris, let me also mention that every case of discrimination, whether it's in housing, places of public accommodation, employment, credit, and in certain areas of education, must be filed at the MCAD first. The exception is housing. You can go straight to housing court if you have a housing complaint. But the remainder of those cases, the statute calls for exhaustion rights at the MCAD. So you must file your case at the MCAD before you can proceed to court.
I know we've been talking about individual cases here, but looking over the history of MCAD, is there anything that really makes it clear to you that this agency has made a difference in how we normally do things now?
Well, I have been at the agency for almost 18 years now, and you would think that after 70 years, we're about to celebrate our 70 years next year of the Commission's when the commission started. And you'd think after 70 years that we would have achieved our mission of eradicating discrimination. And the truth is, we still have a long way to go. We still see cases that are very valid, that go to public hearing, that are found in favor of the complainant, the charging party. So we know that there's still work to be done. We know that in so many ways there's still laws that need to address. We recently put gender identity on our books so that people who are transgender can be protected in employment and in housing. We also worked very hard to get parental leave so that fathers could also have the same privileges that mothers experience when their employers gave them 8 weeks of leave after the birth or adoption of a child. Those are laws that are really important, so we still have a lot of work to do. But one of our biggest accomplishments is we're known throughout the country as a leading expert and as a very progressive agency, and Massachusetts, as you know, has some of the best laws to protect its citizens.
Well, if people want to talk about a situation or if they just want to find out more, what's the best way for them to follow up?
Well, we have 4 offices. As I mentioned, we have offices in Boston, New Bedford, Worcester, and Springfield. They can visit any of our offices. They can also go to our recently revamped website, and that website will have a lot of information, and it will talk a lot about our different protected classes. It's news about what's going on at the MCAD. It will talk about our public hearing decisions and give a lot of information about training. Training is really important at the MCAD. We want to let employers know that, you know, if we can give you one bit of advice to any of your viewers, we would say train them. And you can get to our website at www.mass.gov/MCAD.
Remembered it all. Thank you very much for being with us.
Well, thank you for having me. I really appreciate it.
Sunila Thomas-George from the Mass Commission Against Discrimination. Still to come, the growing resistance to the gas pipeline in West Roxbury.